Okay. Welcome to the Peter Fitzpatrick School and continuation of the dangerous dog hearing. All right, like I said, this is a continuation of the meeting dated on the 17th. At this point in time that I'd like to make a motion to deem the dog Sadie as a dangerous dog. Simba.
I'll second that.
Hold on. Are you taking testimony still?
Yes, sir.
Oh, so you can't make a motion to deem a dog dangerous before you finish taking the testimony.
Sir, can you identify yourself,
Sure.
please?
Jeremy Cohen. I'm here for the Tylers.
Okay.
And I'm here to make sure that we follow procedure, most importantly. So I've watched the hearing. You've left it open to take testimony. You've sworn people in to take testimony.
Yep.
So making a motion right now is premature. You can't make a motion until you've heard the rest of the testimony. When you close the evidence, then you can make a motion.
Right now, we have a motion on the floor, which we're not even supposed to be discussing because we haven't seconded it yet. So we're to motion, second the motion, and then have a discussion. Someone might call for a vote at some point, but it does not require us to vote promptly. We can talk all night if you like.
The reason I'm here and the reason this is important to me is because due process is important. And due process means that the government, even local government, cannot take your property without a fair hearing. And part of a fair hearing is knowing the claims against you and being able to answer for them. And so I'm here just to make sure that we get to whatever the right decision is the right way. I need to clarify a few things. There was a lot of testimony at the last hearing, and it was part of Ms. Scarsdale's comments at the end of the last hearing too, was that there was a prior order in place that my clients were in violation of. So in the packet, on the second page, these are the Pepperell bylaws or the code of the town of Pepperell. This alleged order that was in place, it absolutely was not in place. It was an unlawful order, and I just want to explain why briefly. So under your own bylaws, 81-7, point 1, authority to temporarily restrain or muzzle. The dog officer is authorized and empowered to temporarily muzzle, restrain, or order the owner of a keeper of a dog to muzzle or restrain a dog pending a hearing before the Board of Selectmen when the dog officer finds that the dog has bitten or threatened any person. The muzzling, restraining, or the order to muzzle or restrain shall be in effect for 45 days or until the Board of Selectmen issue the decision. So we know that no hearing was held back in 2017. That order expired 45 days after the animal control officer verbally put it in place. So in reviewing everything from the last hearing, everyone seemed to be operating as though there was this prior order in place that had already been violated. What should have happened was that the animal control officer should have requested a hearing, as she could do, and she didn't do that. The evidence that was presented at the hearing last, 98% of it, if we go to court, isn't admissible. And I'm just asking that while the rules of evidence don't apply here, you have a job to do, a tough job to sift through what's hype and what's facts. I heard that if whatever dogs did it, they're vicious, they're horrible, they should be euthanized. Well, the vet bill was $1,000. There wasn't surgery. The dog was put under general anesthesia, drains were put in, sutures were put in. A lot of that, $200, was just to look at the dog. If these dogs were really dangerous, there would have been human aggression. Dog-on-dog aggression does not get any dog, whether it's my clients or anyone else's, killed. There's been no human aggression, and whoever these dogs were when they were there had ample opportunity to bite Mr. Ford, and they didn't. He was able to grab one of them and hold it, and it didn't. So while we still maintain that before I took the case, I said, come on, how can it not be? But now I've looked at everything, and I see how it could not be their dogs. Now, your letter said that we are having a dangerous dog hearing about the December 20th incident. Really? because you went for 2.5 hours hearing about every possible sighting and incident that could have happened, so much so that it even confused the board, who luckily we clarified nothing on record has happened since March of 17. So from March of 17 through now, there's been no written report. Everybody has an issue, but nobody thought to call the animal control and report it. And that's because with the pitchfork crowd and over time, embellishment and hype and take over, you need to look at the facts and you've got nothing. All that being said, there's a lot of problems in this area where these folks live. But they want to try to show that they're engaged in this, whether their dogs did it or not. And some of the things they've told me that they're willing to do amazes me in the face of there's no proof that their dogs did this. But here's what they're willing to do. Since there was never an order in place after that first 45 days, they will accept an order that they will build a fenced-in kennel with only access from the house into the kennel, obviously on the property. So that gives everybody the peace of mind that, well, and it will be inspected, it will be dig-proof, it will be what the statute calls for in here, under 140, 157. No one will see these dogs off on the property without a leash on. And if they do, they should take a picture of it. Take a picture and share it with animal control or a member of the board. They also are willing to keep insurance in place. The dogs are already microchipped. They're willing to step up and say, we don't have evidence that our dogs did it, but there's people who are scared out there. So we'll take some responsibility for that. We'll do what the statute says. We'll do numbers 1 through 6, just not number 7. Just not kill them. In your packet, I included Mass General Law 140, 157A. So that's what comes after the dangerous dog statute. This is what happens for non-compliance of an order. So you could, in theory, vote that a dog is a nuisance dog and put in remedial measures any order you want. But this is what the power the town has. An owner or keeper of a dog who fails to comply with an order of the hearing authority or a district court shall be punished by a fine of not more than $500, imprisonment for not more than 60 days, and also you're entitled to seize the dog without a hearing. Since we have no proof that they've been off property or done anything since 2017, but you want to do something for the community, put in an order like this, and then if they break it, now it's on them. Now we know they're being held to this standard. And if they don't maintain it, you've got teeth. This isn't just about a fine that your town allows. This is about seizing the dogs, putting somebody in jail you have the power to, and fining them. And that's just for the first offense. I'm just asking that we bring a little bit of reason here and try to find something that can at least bring some peace to the area and give everybody some empowerment that if something were to happen, just take a picture, take a video, and give it to the authorities, and then it'll be pretty tough to dispute it, and suddenly you have them violating an order and having to face the consequences.
So for me, whether procedure was followed in 2017 or not, another dog was viciously attacked, almost died, required drains. Megan and Ryan are not disputing that their dog did attack this other dog in 2017. So I make a motion to deem the red hound mix a dangerous dog.
Second it?
I'll second it.
Okay, you gonna second?
Yep.
All those in favor?
Aye.
Okay. Now, I don't believe that this is the dog's first strike, so I believe that we should do 1 through 6.
I am thinking about the day of that attack and the testimony that we heard, and we have an obligation to keep people and livestock in Pepperell safe. It was an unprovoked attack. They traveled over, they set upon this dog what I believe And I can't be sure that, I couldn't say, well, that could never happen again. I would vote that that dog also be humanely euthanized.
Oh, Margaret.
It's a valid point where the dog didn't run away like the other two. But I don't think there's history. You know, the other one had history of other attacks.
Okay, then I make a motion that we restrict the dog 1 through 6 under the Mass General laws.
I'll second that.
All those in favor? Aye.
Aye.
Opposed?
Opposed.
Okay. All those in favor of taking no action signify by saying aye. Aye. All those opposed?
Opposed.
Okay.
So to the audience, I'd like to sort of summarize the action the board has taken so far. The first is for the dog named Simba. They have voted to declare the dog dangerous and have also voted to order the dog euthanized. In the case of the dog named Brady, they have voted to deem the dog dangerous and have voted to impose restrictions 1 through 6 in the Massachusetts general law, which Chairman Grade had read into the record a few minutes ago, but it includes restraint and kenneling, muzzling when out in public, proof of insurance, proof that it has been, is identifiable, there's various means for that, and also that it must be altered if it is not already. I believe that summarizes that piece of it. And then finally, for the dog named Sadie, the board voted to take no action on it at this time.